So something absolutely massive just hit the Supreme Court docket, and the timing of this could not be more significant. An emergency request has been filed asking the justices to immediately block enforcement of short-barreled rifle restrictions and potentially dismantle major sections of the National Firearms Act. But here's what makes this even more explosive. This emergency petition landed just weeks after the Supreme Court delivered a cold, hard no to previous NFA challenges, leaving millions of gun owners wondering if the High Court had abandoned them entirely. Before I break down exactly what this emergency request says, why it could succeed where previous challenges failed, and the hidden legal strategy that might actually save the Second Amendment in the long run, you need to hit that subscribe button right now. The Supreme Court could respond to this petition within days, and the legal landscape is shifting faster than at any point since Bruen came down. You cannot afford to miss what happens next. Let me set the stage for you, because understanding what just happened requires knowing what died just a few weeks ago. We had two major vehicles heading for the Supreme Court: Rush v. United States and the Robinson Challenge. Both cases were asking for emergency review, telling the justices that lower courts, specifically the Seventh Circuit, have created a state of absolute chaos. In the Rush case, the Seventh Circuit essentially ruled that short-barreled rifles aren't even arms protected by the Second Amendment. Think about that for a second. According to that court, a rifle with a 16-inch barrel is a constitutional right, but a rifle with a 14.5-inch barrel is a dangerous and unusual machine that the Constitution doesn't even recognize. Second Amendment advocates were certain the Supreme Court would slap this down, but the response we got? Cert denied. No explanation, no dissenting opinion from Justice Thomas or Alito. Nothing. This left millions of gun owners in Illinois, Indiana, and Wisconsin under a legal precedent that says your short-barreled rifle has zero constitutional protection. The denial felt like a betrayal, especially from a court that many believed would use Bruen to dismantle the National Firearms Act piece by piece. But while everyone was processing that loss, something unusual happened. The emergency application that just landed on the Supreme Court's docket isn't just another cert petition. This was filed directly with the court's emergency docket, rather than going through the normal appellate process. The petitioners are asking for what's called a stay of enforcement, which means they want the Supreme Court to immediately stop the government from enforcing NFA restrictions on short-barreled rifles while constitutional challenges work their way through the system. Here's what makes this different from Rush and Robinson. Those were cert petitions asking the Supreme Court to review final judgments from lower courts. This is an emergency application arguing that irreparable harm is happening right now to gun owners across the country. The legal standard is completely different. For emergency relief, petitioners have to show four things: a reasonable probability they'll win on the merits, irreparable injury without intervention, that the balance of equities favors them, and that an emergency stay serves the public interest. Now here's where things get really interesting, and frankly a little controversial for some in the Second Amendment community. When those earlier NFA challenges started moving toward the Supreme Court, many expected the Trump administration's Department of Justice to simply lay down their arms and refuse to defend the National Firearms Act. But that's not what happened. In recent filings, the Trump DOJ actually urged the Supreme Court to deny those cases. They argued that the NFA's registration requirements are still presumptively lawful and that the Supreme Court's decision in United States v. Miller already settled the issue. Why would a pro-Second Amendment administration do this? Legal insiders suggest the DOJ is playing a high-stakes game of strategic sacrifice. They want the court to focus on the Illinois AR-15 ban instead. Their logic is simple. If you win on AR-15s, you win for millions of people at once. If you win on short-barreled rifles first, you're fighting over a niche category that the media can easily paint as dangerous and unusual. But this emergency petition flips that entire strategy on its head. While the lawyers were arguing in court, the ground beneath them just shifted. On January 1st, a massive provision in recent legislation officially took effect, and it changed the NFA forever. For the first time since 1934, the tax to make or transfer a short-barreled rifle, a short-barreled shotgun, or a suppressor has been reduced from $200 to $0. This wasn't just a gift to your wallet. It was a legal landmine planted deep inside the NFA's foundation. The emergency petition makes this $0 tax the centerpiece of its legal theory, and the argument is brilliant in its simplicity. The entire National Firearms Act has always been justified as an exercise of Congress's taxing power. When the Supreme Court upheld the NFA back in 1939 in United States v. Miller, they did so specifically because Congress has broad authority to levy taxes. The court never analyzed whether the NFA was a valid gun regulation under the Second Amendment because at that time, the court hadn't recognized that the Second Amendment protects individual gun ownership at all. But here's the problem the government faces now. If the NFA tax is $0, what exactly is Congress taxing? You can't have a tax law that generates no tax revenue. That's not a tax, that's just a regulation with paperwork requirements. Remember, the only reason the Supreme Court upheld the NFA in 1939 was because it was a tax law. Congress used its power to tax to regulate guns, they couldn't ban outright. But if the tax is zero, there's no revenue being collected, and if there's no revenue, it's no longer a tax law. It's just a gun regulation that has to survive strict scrutiny under Bruin. Several new lawsuits are calling this a registry without a reason. The DOJ is scrambling to defend this, claiming the registry helps enforce special occupational taxes on businesses, but the argument is thin. Without the taxing power as constitutional justification, the NFA has to stand or fall purely as a gun regulation subject to Second Amendment scrutiny. And under that scrutiny, the petition argues, these restrictions can't possibly survive because the government never presented historical evidence showing that short-barreled rifles were regulated in early America. The timing of this emergency request matters more than most people realize. The Supreme Court just denied cert in Rush and Robinson weeks ago. Usually, when the court denies cert in cases raising similar issues, that signals they're not interested in the topic. Lawyers typically wait months or even years before bringing similar challenges back. But this emergency petition was filed almost immediately after those denials. That's extremely unusual, and it suggests the petitioners believe they have a fundamentally different legal theory that addresses whatever concerned the justices about those earlier cases. Think about what else the NFA regulates beyond short-barreled rifles. Suppressors, short-barreled shotguns, any other weapons as defined by the ATF. If the legal foundation of the NFA collapses because it's no longer a valid tax law, all of those restrictions come into question simultaneously. We're not talking about just one type of firearm anymore. We're talking about the entire regulatory apparatus that's existed since 1934. The emergency petition argues this makes the case far more consequential than state assault weapon bans affecting a handful of states. This affects federal law enforced in all 50 states. The petition specifically points to the chaos in the lower courts. Since Bruin came down, federal circuits have issued completely contradictory rulings. The 7th Circuit says short-barreled rifles aren't protected at all. The 5th Circuit suggested in dicta they probably are protected. The 9th Circuit has been all over the map depending on which panel hears the case. Your Second Amendment rights have become a geofenced reality. In the 5th Circuit, courts are striking down federal regulations left and right, looking at history, and concluding there's no American tradition of banning people from owning specific types of bearable arms just because they're modern or compact. But in the 7th and 2nd Circuits, courts are using a shuttering technique, essentially closing their eyes to Bruin and relying on Miller to say that if a gun is too concealable or too powerful, it's not protected. The emergency petition makes 4 core arguments designed to appeal to different justices on the current court. First, Bruin requires strict scrutiny of all gun regulations, and the NFA can't survive that scrutiny. Short-barreled rifles are bearable arms, which Bruin held are presumptively protected. The government has never presented historical evidence of regulations analogous to the NFA's registration and taxation scheme. Second, the circuit split is causing immediate harm that requires emergency intervention. Gun owners in different circuits have been told completely different things about whether their firearms have constitutional protection. This creates a situation where your rights depend entirely on which state you live in, even though we're talking about federal law. Third, the $0 tax fundamentally changed the constitutional analysis, making this a new issue the court hasn't previously addressed. The Supreme Court has never analyzed the NFA as a pure gun regulation under modern Second Amendment doctrine. This is genuinely a new legal question about whether Congress can maintain a regulatory scheme after the constitutional basis for that scheme disappears. Fourth, the public interest favors clarifying Second Amendment rights rather than allowing prolonged uncertainty. Millions of Americans own firearms that may or may not be constitutionally protected. The ATF is spending resources processing applications under a law that may be unconstitutional. Both gun owners and law enforcement need clarity. There are 3 realistic outcomes for this emergency petition. Outcome 1. The Supreme Court grants the emergency stay and blocks enforcement nationwide. This would be a massive victory, signaling that at least 5 justices believe the petitioners are likely to win. The ATF would have to stop all NFA prosecutions for short-barreled rifles, stop processing applications, stop denying applications, and stop enforcing registration requirements. This would put enormous pressure on the government to settle rather than risk a final ruling that could take down the entire NFA framework. Outcome 2. The court denies the emergency stay but grants certiorari to hear the case on the merits next term. This would be mixed. No immediate relief, but it would mean the court is taking the issue seriously. A grant of cert would give both sides time to fully brief the issues and for the court to hear oral arguments. Outcome 3. The court denies both the emergency stay and certiorari. This would be the worst outcome, leaving the 7th Circuit's ruling in place and allowing the circuit split to continue. However, even this wouldn't end the fight. The $0 tax challenges would continue in lower courts. Here's the silver lining that most people are missing. While the court denied the emergency NFA requests, they did something unusual with 2 other major rifle cases at the exact same time. The challenges to the Illinois AR-15 ban and the California magazine ban weren't denied. They were relisted. In Supreme Court language, a relist is a signal. It means the justices are discussing these cases in their private conferences. They aren't ready to throw them away. The fact that they keep holding on to these cases suggests they're looking to settle the common use question once and for all. If the court rules that the AR-15 is a protected arm, the 7th Circuit's logic and rush collapses instantly. The Supreme Court is playing a long game. They aren't turning these cases away because they love the NFA. They might be turning them away because the $0 tax creates a brand new legal theory that hasn't been fully tested in lower courts yet. By zeroing out the tax, Congress may have accidentally handed the Second Amendment movement the silver bullet needed to kill the NFA entirely. The Supreme Court knows this, and that's likely why they're being strategic about which cases they take and when. The next few weeks are absolutely critical. The Supreme Court will likely act on this emergency petition within 2 to 4 weeks. Emergency applications get priority treatment. When that order comes, watch for whether the court requests a response from the government. That's actually a good sign for petitioners because it means the court is taking it seriously. Watch for how quickly they order a response and what deadline they set. A short deadline suggests urgency. Also watch whether any justices publish dissents from whatever decision the court makes. If the court denies the emergency stay but Justice Thomas writes a dissent joined by Alito and maybe Gorsuch, that tells you there's significant interest even if there aren't 5 votes for emergency relief right now. If this breakdown helped you navigate the legal fog and understand what's really at stake, smash that like button and let me know in the comments. Do you think the Supreme Court will grant emergency relief, or are they waiting for the perfect case? Make sure you're subscribed with notifications turned on, because when the court issues their order, you'll want to know immediately what it means and what happens next. This is the most important Second Amendment case you're not hearing about yet, and your support keeps these critical updates coming. Stay safe and stay informed.